Hey, good morning, Judge Morrow.
Good morning, Francois. How are you today?
Good. Look, I just wanted to let you know we missed you on yesterday. I don't know. I said we missed you on yesterday. I don't know if you took the day off.
No, I was supposed to be at a meeting yesterday afternoon, but traffic court ran long, so I wasn't able to do it. So you're not even going to have me this afternoon because I have to do that meeting today. So sorry.
Yeah, we didn't leave till 6 o'clock yesterday with Mr.
Oh my gosh, I'm sorry to hear that.
Okay. Judge Morrow, I'm letting
Say it again.
I'm letting South Annex go first today.
Oh, okay. Thank you.
The South X is just coming on.
Okay.
Good morning, Your Honor.
Good morning.
Um,
I hear you're going first this morning, so whenever
yes,
you're ready.
yes, I'm ready. We started with, come on, Ms. Toy Clark. That's position 8 and 9, Your Honor. Hi, Judge.
Good morning. Good morning, Mr. Howard. This is your case?
Yes, Judge, good morning.
Okay, good morning. Good morning, Ms. Clark. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Ms. Clark. Good morning, Ms. Story.
Good morning, Your Honor. The offer in this case is 12 for position 8 is 12 months to serve 46 days, credit for time served 23 days. The balance probated in FIP course, no contact with Precious Minnick nor Tyrone Gibbons. And a stay away from 176 Troy Street in Atlanta. For position 9, it's 12 months to serve 48 days. Credit for time served 24 days, the balance probated. An anti-theft course, $200 of restitution to Tanika Terry. No contact with her in the same stay away address, nothing further.
Thank you, Mr. Howard.
Judge, this is a negotiated plea on both cases. On position number 8, we do have, I didn't have a chance to ask Ms. Sorry about it, but I'd like to have the contact to be changed from no contact to no further violent contact with Tyrone Gibbons, who is her adult son. It's her understanding that he is actually in custody in Savannah, Georgia. But given that this was an incident from 2 years ago, they've had contact since then. So I would ask that if you no further violent contact with him. The other person, Ms. Minnick, was the brother's girlfriend, which she doesn't have a reason to have contact with her. But we would ask for no further violent contact with Tyrone Gibbons.
Is there
No-
any? Okay,
No
go ahead.
objection from the state.
Okay. So no further violent contact with Mr. Gibbons. Anything further, Mr. Howard?
Nothing further, Judge. We ask you to set the plea as negotiated. We do stipulate the venue, ID, and a factual basis for the plea.
Okay. Ms. Clark, it's my understanding that in case 20 CR 005926A, you wish to plead guilty to simple assault, family violence, and simple assault. And in case 20 CR 005927A, you wish to plead guilty to theft by taking. Is that correct? You're on mute, South Annex.
Yes, correct.
Thank you. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Very much so. Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
No, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Ms. Clark. I'm gonna waive the probation fees for you while you're on probation to
Thank you.
help you get and stay on your feet. You're welcome.
Thank you so much, Judge. You have a happy holiday.
Okay, you have a happy holiday also, Ms. Clark.
I'm done.
Hold on, please.
Unless there's anything else.
Oh, baby, let me get up.
Okay. You take care, ma'am.
Thank you.
You're welcome.
Next, we have position 18, April Jones.
Yes. And this is also a negotiated plea.
That's correct, Judge. Good morning.
Good morning, Ms. Helen. I hope you're well.
I am. Thank you, Judge.
Good morning, Ms. Jones. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Good morning, Ms. Todd.
Good morning, Judge. How are you?
I'm doing well, thank you.
So the offer in this case is going to be time served and a stay away from the MARTA 5-point station.
Ms. Helen?
And yes, Judge, that is our understanding of that plea. We do accept it. We do stipulate to the factual basis, venue, and ID.
Ms. Jones, it's my understanding that in case 22 CR 008-043E, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
Being represented by counsel, are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Jones. Good luck to you, ma'am.
Thank you, Judge.
Okay. Ms. Todd, do we know how many days that she's been in custody?
I can get that for you, Your Honor, if you'll indulge me for just 1 second.
Okay, thank you.
Judge, I had 14 days, but if I could just be verified by Ms. Todd, that'd be great too.
Okay.
We have 14 days as well, Your Honor.
Okay, thank you.
Thank you, Judge.
Yes. Who do we have next?
This is gonna be positions 1, 2, and 3 on the add-on calendar, Mr. Grimes.
Okay. Okay, so for position 1, I have a non-negotiated plea. For position 2, an arraignment, and position 3, there was a null process. Is that right?
That is correct, Judge.
That's correct, Your Honor. Actually, position 1 is going to be a negotiated plea. Other than that, that is correct.
Okay. Let me get the arraignment out of the way first, and then I'll take the plea. Good morning, Mr. Grimes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Grimes. Mr. Grimes, in case 21 CR 005143J, you've been charged with simple battery family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation? Ms. Helen,
I do, Judge.
how do you plead, Mr. Grimes, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Was there a request? This is just an arraignment, is that correct?
That's correct, Judge.
Okay, let's see, let's go to position 1. Good morning, Mr. Walker.
Good morning, Your Honor.
Whenever you're ready.
Okay, the state's recommendation is going to be 12 months to serve 4 days, credit for time served 2 days, balance probated, an anti-theft course, and a stay away from all Walmarts within Fulton County.
Ms. Helen,
Yes, Judge. Yes, Judge, we do accept that offer and we do stipulate to the factual basis, venue and ID, Judge. It is a probated sentence. We are asking for those probation fees to be waived. And if the state is amenable, once he completes that theft class, can the probation be terminated?
We can do non-reporting.
Okay,
He agrees, Judge. Non-reporting will be fine.
all right. Mr. Grimes, it's my understanding that in case 21 CR 001393J, you wish to plead guilty to theft of lost or mislaid property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Grimes. I am going to waive the fees for you while you're on probation. And as soon as you get the theft course completed, it'll go to a non-reporting status, okay?
All right, thank you, sir. You have a blessed.
You do. You also, Mr. Grimes. Thank you. Let's see. I have Miss Grace in court with me today. If you will get your paperwork to her as soon as possible, the null process and such also from the state.
Understood, Judge.
I do understand that you all are in court and we'll have to do that after court, Ms. Helen, but as soon after as you can. All right, who do we have next?
It's gonna be position 1, Alavir. He's on the regular state all-purpose calendar.
Okay, thank you. And it's going to be an arraignment and a bond hearing.
That is correct, Judge.
If you can get me that bond paperwork when you get a chance, Ms. Grace. Yes. Good morning, Mr. Alvier. I'm Judge Eric Mara. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Alvier. You've been charged in case 22 CR 008045D with battery family violence. This charge carries a maximum penalty of 12 months in jail and to $1,000 fine. Do you waive formal reading of the accusation? Mr. Howard,
We do, Judge.
how do you plead, Mr. Alvier? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. It's my understanding that there's a $25,000 good bond that was set on November 30th. Can I get his history, please?
Morning, Judge. I have
Discussion.
4 cycles. Last arrest was March of 2017, failure to appear. Underlying charge was not indicated. That was in Fulton County. I have a conviction in 2017 for aggravated assault out of Clayton County. And one second. A battery, family violence, first offense. That's also out of Clayton County. And a 2017 driving while license suspended, nothing further.
The battery family violence, what year was that?
That was 2017.
Okay, so everything's been in 2017, it
Yes.
sounds like. Okay, thank you. I appreciate it, Ms. Harrison.
Yeah.
Ms. Sari, could you give me the facts of this case?
Yes, Your Honor. This incident took place at 454 Hamilton E. Holmes Drive in Atlanta. The victim in this case is a 6-year-old. He's the son of the defendant. Officers actually responded to the Hugh Spalding Children's Hospital in regards to a child abuse call. The victim had bruises on his back and arms in various stages of healing. He went to his grandmother's home to visit her when she discovered the bruises, and she took him to the hospital. The victim told officers that the defendant whooped him with a belt and a 2x4. As we've heard from pretrial, Your Honor, the defendant does have a 2017 battery family violence. he used his first offender on that, and I do believe that was a different victim. He has an FTA from 2017, so he does present a risk of reoffending, and he is a flight risk. And Your Honor, we just want to emphasize that this is a 6-year-old. We do understand corporal punishment. However, whooping a child every day and whooping them with a 2x4 is not corporal punishment. So we are asking that the bond remain as set, nothing further.
Thank you, Mr. Howard.
Yes, Judge. Mr. Alvear has been a resident of Georgia for more than 17 years. His dad, his uncle, other relatives live here in the immediate metro Atlanta area. He's a graduate of Douglas High School. He works as a self-employed contractor, rehabbing and renovating houses. So he's done very well with that. He certainly has ties to the area and has no intention of leaving the area. Judge, we do hear about the 2017 FTA. We talked about that. He indicated it was just an address issue, not an issue where he was trying to abscond or not appear for court. Outside of that, Judge, we heard 2017 cases, but none would be, I guess, similar to this. And this is absolutely a case where Mr. Alvear was exercising what he believed as reasonable corporal punishment. And certainly that's an issue that can be decided later by a jury, but there was no 2x4 involved. That is absolutely untrue. This was a situation where it was, in his mind, reasonable corporal punishment. Grandmother, we believe, who had some other issues with him and his daughter, overreacted, and she did what she thought was best, but clearly he was not intentionally harming his child. He's made attempts to regain his child since then, and because she had called the police, he actually called the police when she wouldn't return the child, but they indicated she had already called the police, so he was not able to file a report as it relates to that. Judge, we would ask that the court lower the bond significantly. The court is not inclined to do a signature bond. We'd ask that it be a $2,500 good bond so that he might have an opportunity to potentially post bond to fight these charges and assist his attorneys with preparing a defense in this case. So we'd ask that it be reduced to $2,500.
And Your Honor, briefly, there is an open defects case regarding this incident, and our office has sent this over to the DA's office for review for cruelty in the first or second. So this is being reviewed as a felony. The victim's grandmother, she actually has custody over the victim due to this incident. So it is a very serious situation, Your Honor. That's why the bond was set as it was. So we are asking that it remains.
Thank you. I'm going to lower the bond to $10,000 good bond with the same conditions. No further contact with the minor. Stay away from the grandmother's house at 5705 Rivertown Road. No drugs, alcohol, or weapons while out on bond.
Judge, could we ask that the order as it relates to contact with the child be amended to reflect that if only if DFAC decides that contact is appropriate, that he will be allowed to have contact?
If DFACS decides that, Mr. Howard, then he can seek to modify the bond at that time. So let's just see what happens with DFACS, and if they do support your position, then I'm happy to look at it again. Okay.
Thank you, Judge.
All right.
Thank you.
Yes, that's correct. Good luck to you, Mr. Alvarez.
Thank you.
Position 23, Mr. Perry.
So are you going to represent him, Ms. Helen? I've got down that he's pro se. What's going on with him?
Judge, I came yesterday to speak to Mr. Perry. He explicitly told me he did not want the services of the public defender's office. However, he would like the opportunity to speak to this court as a pro se individual, Judge.
Okay, good morning, Mr. Perry. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Perry, you can put your hand down. Thank you, Mr. Perry. Mr. Perry, you have a right to remain silent. Anything you say can't be used against you. You have a right to have an attorney represent you at these proceedings. We have provided you with the services of the public defender. It's my understanding that even though she's sitting right there next to you and ready to represent you, you would like to represent yourself. Is that correct?
Yes, sir.
Why is that, Mr. Perry?
I'd rather, talk on my own behalf.
Okay, well, let me just tell you, she's a lawyer and you're not a lawyer. And a lot of
I'm
times,
a dictator, so I read.
okay, okay, I'm just want to put this on the record so you know that I've told you this, okay?
Yes, sir.
So just listen to what I'm about to say. A lot of times people will want to speak to me, but also know that you're speaking to the solicitors that are on this call. Anything you say can be used against you. Quite often, people think that what they say is going to help them, and in turn, it actually turns out to not help them because they're not a lawyer. They don't, quite often know what is helpful and what is not helpful. That's why we, at this point, try to provide you
I'm
with
fine, I can represent myself.
with a lawyer to help you.
I'm
So,
late, I can represent myself.
okay, so let me just tell you, Mr. Perry, you've been charged in case 22 CR 008053G with simple battery. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. You understand that?
Yes, sir.
Okay, what would you like to, knowing that you have a right to remain silent, what would you like to tell the court?
What happened was I was asleep on the MARTA train and I had a purse with my money in it. I guess the girl didn't think I was supposed to have a purse. And the MARTA people woke me up and they said, I had a lot of money in the purse. And they said some girl said I touched her. And I said, well, okay, go and take me in, because I didn't know whether, sometimes people try to, wake you up tell you different things. I said, simple thing, go and take me in. I just wanted my money and my purse back. And they took my money in my purse.
Okay, so today, Mr. Perry, you've been charged with simple battery, I guess, for the incident. How do you want to plead to that? Are you going to plead guilty or not guilty?
Not guilty.
Okay. And you, let's see, since you're going to plead not guilty, Mr. Perry, you have a right for me to read the accusation to you if you want, or you can wait for a reading of the accusation. Do you want me to read what you're accused of to you?
Yes, sir.
All right, now let me get that accusation. I'm happy to read it to you, Mr. Perry. Can you print that out for me? Thank you. The accusation reads as follows, Mr. Perry. In the State Court of Fulton County, State of Georgia, versus Christopher Perry, defendant, accusation number 22 CR 008053G, simple battery. I, Keith E. Gammett, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Christopher Perry with the offense of simple battery, a misdemeanor, for that said accused in the County of Fulton, State of Georgia, on or about November 16th, 2022, did intentionally make physical contact of an insulting or provoking nature with the person of Cynthia Hall by touching her without her consent in violation of OCGA Section 16-5-23, contrary to the laws of this state, the good order, peace, and dignity thereof. Signed, Keith E. Gammett, Solicitor General. It's my understanding that you're pleading not guilty. Is that right, Mr. Perry?
Yes, sir.
Okay, we will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Perry.
Yes, sir.
Position 28, still.
If I can get Mr. Stills. Bond order also. Good morning, Mr. Still. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you. You can put your hand down, Mr. Steele. You've been charged in case 22 CR 008061F with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Steele? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. I have down that a bond was set on November 30th of $3,500 good bond with conditions. Let me start with his history. Ms. Harrison.
18 cycles, last arrest June of 2017 for possession of marijuana less than an ounce, possession of firearm during the commission or knife during the commission of a felony, theft by receiving stolen property, possession of controlled substance in Schedule 2, possession or sale of marijuana, and possession of Schedule 1 or 2 with intent to distribute in Clayton County. No disposition is listed on that arrest, but GCIC does indicate a hold in Clayton County. Also, record indicates an open probation for theft by receiving stolen property, purchase, possession, manufacture, or sale of marijuana, possession of Schedule 1 or 2 controlled substance with intent to distribute. Case number 17 CR 02577, sentenced March of 2018, 5 years probation. 2 failure to appear and 2 violations of probation within the past 10 years. Nothing further to add.
All right, thank you, Ms. Harrison. Ms. Todd?
Yes, Your Honor. On March the 2nd, the defendant and the mother of his child were driving down I-75 when they got into a verbal altercation. The defendant decided to escalate the situation when he punched Ms. Shakira Hughes, that's SHAKIRIA, Hughes, common spelling, in the head, giving her a black eye. This, as pretrial stated, he does have prior cycles as well as FTAs and probation violations. We do believe he does present some risk of flight. We also do feel that he risks reoffense here, Your Honor. He does have those prior cycles, as well as he currently shows to have an open warrant out of Jonesboro. We do fear for risk of intimidation of the mother in this case. They do have close contact, seeing as that is his child's mother.
Thank you, Ms. Helen.
Yes, Judge, this is a bond hearing today for Mr. Still. When I came and spoke to Mr. Still about this situation, again, Judge, he doesn't have the history of a long-standing violent offender, not with anyone, not with the community, not with anyone in his family. This is the first of that kind of charge. And when I spoke to him, this was an argument in the car, Judge. And so we're having a bond hearing. Mr. Still is not able to make the $3,500 bond. He's not been able to make that since it's been set. He is the main financial provider of his family, Judge. He does help with that family. He's a long lifetime resident of Fulton County, Judge, and so is his family. I just asked him who iPhone 2 is. That's his mother. So he does have long-standing supportive family members here in Fulton County, Judge. So we are asking for that bond modification to no more than a $1,500 surety bond. Again, Judge, giving him an opportunity to bond out. I just wanted to speak on, I did also give the link to Ms. Hughes. I have information that she wanted to testify in defense here. If she could be sounded for as well, Judge. When I spoke to Mr. Still again, they actually want to try to mend this relationship, Judge. And so I am asking for that bond modification, no further violent contact. And going forward, Judge, if again, it can be modified to no further violent contact. But I would ask if it can be sounded for from Ms. Hughes on the Zoom link.
If Ms. Hughes is on the link and would like to testify before this court, this is her opportunity to do so. Is that you, Ms. Hughes, with the crown your flower? Okay, raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
And what would you like to tell the court?
It was just it was an incident that, you know, us being new parents and us trying to just figure life out. It was just, you know, something that was just, you know, we were just too emotional that day. I'm really seeking counseling for both of us. We still have a small child. I don't want to get emotional because it is the holidays, and he is the provider of my family, but we just new parents, and we just trying to figure it out. And he's not like mean or violent. I don't fear for my life or anything like that. It's just we just new parents, and we just trying to do what's right for our child. And we were just he was trying to get the phone from me because I was too excited, and it was just an incident where it just, one thing led to another. But I'm seeking counseling for us if we can get there.
All right, thank you, ma'am. Anything further, Ms. Helen?
And Judge, again, just going to the Ayala, I don't believe he's gonna reoffend. This is the first type of charge. Again, he doesn't have a history of a long violent offender. I don't believe that there's gonna be any danger or intimidation of the witness. She's here testifying for him, to come home, be a part of their family and be a main provider. I also would ask that stay away be modified. I don't believe Ms. Hughes is at the 1111 Westview Drive. They're at a new address, so I just asked that there be no stay away, but they're not at that.
And can I say one thing? His mom is on the line because she's very active in her grandson's life, and she's willing to be a third party until we can get counseling.
All right, anything further, Ms. Helen?
No, Judge, thank you.
All right, based on his history, my concern is that he's not going to show up to court again. He didn't show up. He's got 2 failure to appears. He's got a holdout of another county. I think a $3,500 good bond is generous in this case. As such, I'm going to leave it where it is. Good luck to you, Mr. Steele. All right, who do we have next?
Position 2026, Shelley.
This is a
Says
negotiated.
Mark,
Yes, this is
Um,
a negotiated.
can I check to see where the Spanish interpreter case is? I'm having a hard time getting a Spanish interpreter this morning. But I have Mr. Soka who can do it, but he has another meeting at 10 that he needs to go to.
Do we know who needs an interpreter today?
Yes, Judge, I believe it's position 15.
Yes, he does now.
And yes, he does, Your Honor.
Yes, he
Is he
does.
available in the courtroom at the moment? If so, I can get Mr. Soka to do it, but he has to go by 10.
I'm sorry, Mr. Jordan is coming through a little muffled. We can't hear him quite clearly at the jail. What did he say?
There's
So
an,
I have Mr. Soka who can do the interpreter case, but he has to leave by 10. So I was just trying to see if the gentleman was available for the interpreter case.
What is the name?
It's position 15, Fortino Herrera.
Hold on, I'm checking. Okay, he's actually on the floor. So one of the officers on the floor will be handling that case.
Okay, so I'll see if I can find someone else now. Thank you.
I still need to talk to him for a minute.
okay. So this is Mr. Shelley,
Yes, it is, Judge.
and this is a negotiated plea.
Yes, Your Honor.
All right, good morning, Mr. Shelley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Shelley. Ms. Todd.
Yes, Your Honor. The state's offer is 12 months to serve 30 days. Credit for time served 15 days with the balance suspended.
Yes, Judge, that is our understanding of that offer. We do accept it for Mr. Shelley. We do stipulate to the factual basis, venue, and ID.
Thank you. Mr. Shelley, it's my understanding that in case 22 CR 008056A, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Shelley. Good luck to you, sir.
Position 22, Neil.
I'll make the bond on him also, 22. Good morning, Mr. Neal. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Neal. You've been charged in case 22 CR 0080551C with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Neal? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. It's my understanding that bond was set in this case on November 30th with a $5,000 cash only bond. Let's see. Can I get his history?
Judge, I'm showing one cycle. And I'm showing an open case for battery, family violence, first offense, and a false imprisonment under 22 CP 208928. Nothing further.
Okay, and what, do we have a year on that?
That is, it was filed May of this year.
May of 2022, and this case offense date was November of this year. Yes, thank you, Ms. Harrison. Ms. Todd?
Yes, Your Honor. What started as a verbal altercation between the defendant and his girlfriend, Akaya Ross, was escalated when the defendant tackled her to the ground, punched her in the face, and bit her on the leg, leaving visible swelling. It was only after Ms. Ross threatened to call the police on the defendant that he stopped his attack. I will add that the incident was witnessed by the couple's roommate, Ms. Katrina Bryant. We do raise some concern with this defendant, Your Honor. That open family violence case is against Ms. Ross as well. We do think that, the conditions of the surety bond for that May incident included a stay away order, not only from the incident location, but also from Ms. Ross as well. So it's very clear that the two do have an issue of staying away from each other. We do think that there is a risk of intimidation in this case.
So what you're telling me is that he got a bond where he was in May, where he was told to stay away from the alleged victim. He didn't stay away from her, and then he picked up this new charge in November. Is that right?
That is correct, Your Honor.
All right, Ms. Helen?
Yes, Judge, today is a bond hearing today for Mr. Neal. I would also like to sound for Ms. Ross, see if she's here on the Zoom link today.
If Ms. Ross is present and would like to address the court, this will be her opportunity. Is Ms. Ross present? Doesn't appear so, Ms. Helen.
So Judge, I received several calls yesterday from Ms. Ross. I tried to give her the link today to appear on behalf of Mr. Neal. We're very aware of his history, going over the Ayala factors of reoffending. I spoke to him about the May incident, Judge. For this new incident, Judge, he is under the impression that he did not know that there was a stay away from Ms. Ross, and neither did Ms. Ross know. So I do have calls from Ms. Ross stating that she wanted to come and be in defense for Mr. Neal. And so, Judge, I also have Yolanda Neal also as mom. He has some strong family ties here in Fulton County, Judge. He's turning 21 next month, Judge. So he does have strong family ties. I do not believe he's going to abscond or leave the state. I believe he's going to be living here and working here. When he was working, Judge, he was working for a distribution factory, the Work American News Company. He had been there for several months. He is a high school graduate of a high school Harvard, Judge. And the situation, I think, predicated on the fact that they did not understand or know about the stay away and how serious that condition is, Judge, for this new case to occur, because this is his second cycle. This is his second arrest, Judge. Not being familiar with the judicial system, I have expressed to him that there is a stay away, and that, you know, we really needed Ms. Ross here today to really speak on her also trying to reach out to Mr. Neal. Judge, I am asking for a modification in this case to modify it from the $5,000 cash to $5,000 surety, Judge. He is not able to make a $5,000 cash. That's effectively a no bond for Mr. Neal. So we are asking for that modification, Judge.
Mr. Jordan, are you there?
I'm here, Judge. Sorry, but I was on the phone.
You're
Did you need
fine.
something?
Did you release the interpreter? Because I think that for North hasn't. No, is this not the interpreter case at 4 North? You're on mute, 4 North. Is it?
Yes,
Is this the interpreter case?
Yes.
Okay. Did we release the interpreter, Mr. Jordan?
I can give him a call right back, see if he can do it. Is this gonna be a plea or a bond hearing?
I think that Mr. Ford is just going to need to talk to his client, right, Mr. Ford?
I've already gone over, we were able, between his English and my Spanish, we're able to get through, but I want to make sure he's clear about the verdict, the plea and verdict form, that's all.
Okay, so you're gonna need the interpreter in the breakout room, is that right?
Yeah, that's
Okay.
correct.
Let me see if we can get him back. And if we can, we will, then we'll put you all in a breakout room. Thank you, Mr. Jordan. All right, back to Mr. Neal. Just so you know, Mr. Neal, and I'm gonna make it very clear to you, all right? Stay away means stay away. No further contact means no further contact. It means no physical contact, no personal contact, no email contact, no phone contact, no internet contact, no contact whatsoever. You understand me?
Yes, sir.
Okay. Stay away means you don't go back to the location. You have on your prior bond that you could have a one-time escort to verify occupancy. I'm not sure what the issue was if Ms. Ross was not at that address, but I have made it clear to you what no further contact means. All right, I am going to lower the bond to a $10,000 good bond with the same conditions as the previous bond. But if there's any violation, then that bond is going to be revoked. Any questions, Ms. Helen?
No, Judge.
All right, good luck to you, Mr. Neal. Who do we have next? Ms. Scott, those other charges, are those in Mr. Neal's case, are those the false imprisonment, is it a felony charge?
I can double check that, Your Honor, if you'll give me one moment.
Yes, Judge, it's felony.
Okay, all right, so that's
Okay,
why.
thank you.
Okay, thank you. All right.
We have position 10, Mr. Cruz.
This is going to be jail during a bond hearing also, it's my understanding. Good morning, Mr. Cruz. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me?
Raise your right hand.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, sir. Mr. Cruz, you've been charged in case 22 CR 007899Y with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yep. Yes, we do, Your Honor.
How do you plead, Mr. Cruz? Guilty or not guilty?
Not guilty. Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you will get a notification of your next hearing date. I set this bond on November 21st. It's a $15,000 good bond. Have any of the circumstances changed since I set this bond, which is, I'll just say it's a high bond normally for me, which means that he probably has a history. Is that right, Ms. Harrison?
Yes, Judge.
And can you remind me of what that history is?
Sure. He has 18 cycles, last arrest, November of 2021 for simple battery, family violence, willful obstruction of law enforcement officers in Fulton County. Record does indicate an open case pending. I'm sorry. For simple battery, willful obstruction, 21 CR 006094Y. Additional open case for simple battery, 20 CR 00455660Y. Additional open case for simple battery, family violence, and possession of marijuana less than an ounce, and simple assault, MAGC 02696. 2 failure to appear within the past 10 years. Nothing further to add. I'm sorry, Judge. He has an open felony case, 22 CP 214124 for no violence. It's willful obstruction, reckless driving, possession of Schedule 1 controlled substance, purchase, possession, distribution of marijuana, and driving or fleeing or attempting to elude. Nothing further.
Thank you, Ms. Harrison. Mr. Ford?
Thank you, Your Honor. Your Honor, my client is 31 years old. He has his GED. He was working at Saddle Creek Logistics Warehouse, and he's a lifetime resident of the state of Georgia. He has 3 children, Your Honor, that he is providing financial support for. I have a stable address for Mr. Cruz, also telephone number and email address. He has community support, Your Honor. I have a telephone number for his mother. Your Honor, the change in the circumstances due to the fact that he has the felonies, there has been no bond placed on those felonies. He's hopeful that he will possibly be able to make bond if we can reduce the $15,000 surety to something more, a little less, somewhere around a $1,500 surety. If he is able to get a bond on the felony cases, we're hoping that he can bond out and continue to support his family, Your Honor. So at this point, we're going to ask that the surety bond of $15,000 be reduced to something around $1,500 so he can go back to work and continue to support his family.
I'm going to leave the bond where it is at the present time. If he gets a different bond on that felony case, then you can bring him back to seek a modification at that time. I'm not going to modify the bond at this time. Good luck to you, Mr. Cruz.
Thank you.
Who do we have next?
Position 12.
Okay, that's my case.
Position 12 is also going to be a bond hearing. Thank you. Good.
I'm sorry, Judge. I think Mr. Ford representing him. He can stay on, not leave the floor. He can get him.
Okay, thank you. And this is Mr. Daniel at 5 North, is that right?
Yes, ma'am. I'm sorry. Yes, sir.
Okay, good morning, Mr. Daniel. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Daniel. Okay. Mr. Daniel, you've been charged in case 22 CR 003956Y with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Daniel? Guilty or not guilty?
Not guilty.
Thank you. We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. It's my understanding that there's not a bond on this matter at the present time. What's the history, Ms. Harrison?
9 cycles. Last arrest was March of this year for willful obstruction, simple battery against police officer and terroristic threats. Record indicates that's an open case, 21 CP 202557. Additional open case, 21 CP 918333 for aggravated assault, family violence, false imprisonment, and theft by take-in. Nothing further, Judge.
Ms. Sowry?
Yes, Your Honor. This incident took place at 808 North Elizabeth Place in Atlanta. Officers responded and spoke with the cross defendant, whose name is spelled T-K-E-Y-H-A, last name Wilcox. She told officers that she was in a verbal argument with the defendant because he was cheating on her. When Ms. Wilcox was trying to leave the location, the defendant took her keys and would not give them back. And Ms. Wilcox struck the defendant and a tussle ensued and she sustained scratches. Your Honor, we've heard from pretrial regarding the history. His history is violent, Your Honor. He has a 2012 burglary where he used his first offender, 2016 battery family violence. That was a guilty conviction. In 2017, he was arrested for another battery family violence out of Clayton. I don't see the disposition on that, as well as the open ag assault, false imprisonment, that's in Douglas. And then the 2021 obstruction and simple battery against an officer, that's open. So he has a violent history. He does present a risk of reoffending. The state's recommendation in this case is a $10,000 surety bond, no contact with Ms. Wilcox, a stay away from the incident location, no drugs, alcohol, or weapons, and 1-day anger awareness. Nothing further.
Mr. Ford?
Thank you, Your Honor. Your Honor, my client is 32 years old, and he's a lifetime resident of the state of Georgia. He is a high school graduate of Shiloh in Gwinnett and also has a bachelor's degree from Hertzing College. He's employed at the Americo Logistics, where he's a technician, making a very good wage, Your Honor. He does not have children, Your Honor, but he does have plenty of family support. I do have the telephone number for his mother. I have a telephone number for him and also an email address. He's not at risk of flight. He's not going anywhere, Your Honor. He is a lifetime resident of the Georgia community at this time, Your Honor. So we're asking that his bond be somewhere, if not a signature bond, Your Honor, because as you can note from the facts that have been read, that he has the chance to, the right to defend, the right to have his case heard and plead not guilty. If there's some question about who was the aggressor, there's a cross offended in this matter, Your Honor, So at this point, Your Honor, we're asking that you, if you're not inclined to do a signature bond, Your Honor, we're asking for something around $1,000 surety bond so we can get out and continue his employment.
Okay. It's going to be a $3,000 good bond. No further contact with Ms. Wilcox. Stay away from the 808 North Elizabeth Place address. No drugs, alcohol, weapons while out on bond.
Thank you, Your Honor.
Thank you.
Okay, you're welcome, Mr. Daniel. You'll prepare that, Mr. Ford.
Will do, Your Honor.
Position 20.
Position 16, Mr. Jackson.
Duffy, can I go next?
Yes, go ahead.
Position 29, Taylor.
Okay. This is going to be a negotiated plea.
That's correct, Judge.
Yeah.
Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state on purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Good morning, Your Honor. Yes, Your Honor.
Thank you, Mr. Taylor. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Ms. Todd?
Yes, Your Honor. The state's offer is time served with a stay away from Lenox Mall.
Do we know how much time has been served?
I can get that for you in 1 second, Your Honor.
Can we
I
also have
apologize for.
the address?
Lennox Mall.
Yes.
We can get the address, but you know, he should know where Lennox Mall is.
And Judge, I just have a correction. On Odyssey for Mr. Taylor, I just want to make sure that this is noted. The offense date for this criminal trespass was October 13th, 2022. And I think that's where this Lennox Mall is coming from. But on Odyssey, it says it was added in error. And then instead, there's a November 20th, 2002 criminal trespass, and that's Emory Hospital. So I just want to verify what's going on as far as Odyssey is notating.
Let's see, so we do have, I'm not 100% sure on Ms. Harrison's, I'm sorry if I got your name wrong, question there. We do show that he has been in for 24 days, and I can look into the added in error issue.
What does the accusation say?
The accusation is for the Lennox Mall incident.
Okay, while you all get that together, we do have the interpreter on the line. Can we get, good morning, Madam Interpreter. Mr. Ford,
Good morning.
good morning. Good morning. We're gonna put you into a breakout room. Ma'am.
Thank you, guys.
Okay, so
Okay.
let's go ahead and get them into a breakout room so that they can discuss.
No.
Thank you.
Emory University Hospital.
Okay, I'm being told that the accusation for 22 CR 007890E does say Emory University Hospital.
It does, Your Honor, and I apologize for getting that wrong. I just double checked it.
Okay. Ms. Helen, anything further?
No, Judge, just wanted to make sure we made that correction. And I believe what the credit for time served was 24 days.
Yes.
Thank you, Judge.
Okay, can I take the plea?
Yes, Your Honor.
Mr. Taylor, it's my understanding that in case 22 CR 007890E, you wish to plead guilty to criminal trespass, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Taylor. Good luck to you, sir.
Yes, Your Honor.
Yes, Emory. Right. Who do we have next?
Position 24, Reynolds.
And Judge, if I can have an opportunity to speak to Mr. Reynolds, he was outsourced. So I just want an opportunity just to speak to Mr. Reynolds shortly here.
Okay, is there anybody else that we can take?
Can I just talk to him again?
Position 20. Mr. Oh, actually, that's Helen's case. Hold on.
I know that we have Ms. McLeod on the line and Mr. Murphy on the line. Is it possible to take one of their cases?
Who's for Miss McLeod or?
Good morning, Mr. Murphy. Who's your client?
Christopher Jackson.
Jackson. And good morning, Ms. McLeod. Who's your client?
Good morning, Your Honor. It's Mr. Singleton.
Okay.
Justin Singleton.
Okay, I can do Singleton.
Okay. I tried, Mr. Murphy.
All right,
Yeah,
Judge.
Mr. Jackson is actually going to be on the floor.
Okay.
Okay, you guys switch out for me. This is position 27, Singleton.
Okay. And Ms. McLeod, what are we gonna do with, Mr. Singleton today?
Your Honor, he is going to take a plea, but he also has another matter pending, and I was hoping to see if it could all be resolved in one. He had a case, it's 21 CR 00445H 00445H.
Judge,
Yes,
Judge, as it pertains to Mr. Singleton, I represent him in that case with Judge Taylor. And we're actually set to go in front of Judge Taylor on I believe Monday, the 20th. Let me double check that. Bear with me.
That's correct, Mr. Murphy. I have Odyssey pulled up.
Yes, on 9:30 on the 20th, Judge, because there was a issue of competency.
Oh, well, that presents the issue for this case, man.
Yes, that's why I'm interjecting, just so you know that.
okay, so do you all want to handle all this together on Monday?
There's a chance I can address it with Judge Taylor. That's who I'll be in front of.
Okay, so,
Well, Your Honor, I was thinking since the older case, he represented him in that case, perhaps it would be best for him to also represent him in this matter, Your Honor.
Yeah, I'll be happy to bring it up to Mr. Borger with Judge Taylor. Yes, counsel.
Okay.
all right, so we'll reset this case to Judge Taylor's calendar on Monday. So reset Judge Taylor Monday.
Or it'll be a week from today, Judge, Tuesday the 20th.
Oh, Tuesday, the 20th. Okay.
That's correct, 9:30.
12:20.
And that's a jail jury calendar, Your Honor.
Thank you. All right, so we'll reset for 12:20 with Judge Taylor. Thank you, Mr. Singleton. We'll see you back on next Tuesday, or Judge Taylor will. Ms. McLeod, do you have anything further this
I
morning?
do not, Your Honor. May I be excused?
Yes, have a good day. Thank you.
Thank you.
And Your Honor, not to interrupt you, we're ready on position 24 whenever you're ready.
Okay, so, and this is gonna be an arraignment.
For position 24, Mr. Reynolds is going to be a negotiated plea, Judge.
Okay. Yes. Good morning, Mr. Reynolds. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Ms. Todd?
Thank you, Your Honor. The state's offers 12 months to serve 14 days, credit for time served 3 days with the balance probated, as well as an anti-theft class and a stay away from 10506 Alpharetta Highway.
And yes, Your Honor, that is our understanding of the plea. We do accept that plea for Mr. Reynolds. It is going to be a probated sentence. We're asking for those probation fees to be waived for Mr. Reynolds, just to support him reporting to probation and being successful on that. And also, he agrees to the stay away and the theft course, Your Honor.
Any objection to non-reporting when he satisfies, or termination, whichever? Ms. Todd?
No objection, Your Honor.
No objection to termination?
I'm sorry, no objection to non-reporting.
Mr. Reynolds, it's my understanding that in case 22 CR 003981Y, you wish to plead guilty to theft by taking, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Reynolds. I am gonna waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes.
All right. Good luck to you, sir.
Positions 6 and 7, Clark.
Good morning, Mr. Clark. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Morning, Your Honor, yes.
Good morning. Thank you, Mr. Clark. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hands down. Thank you, sir. Ms. Sauer?
Yes, Your Honor, I'm sorry, is this negotiated plea? Yes. For position 6, the state's offer is 12 months to serve 52 days, credit for time served 26 days, the balance probated, an anti-theft course to stay away from CVS located at 842 Peachtree Street in Atlanta. And for position 7, 12 months to serve 14 days, credit for time served 7 days, the balance suspended. However, to stay away from the 5 Points convenience store at 20 Broad Street Southwest in Atlanta. Nothing further.
Mr. Howard?
Yes, Judge, we'd ask you to accept that plea as negotiated. The only amendment we would need to make is on position number 7. Mr. Clark has only been in custody for 3 days on that case, so if we could amend the sentence to reflect 6 days versus 14 days, because on Odyssey, he's only served 3 days on it. And otherwise, we would ask that his probation be allowed to terminate upon completion of the anti-theft course.
Any objection to any of that, Ms. Sauer?
We would ask for non-reporting due to the history.
And Judge, I didn't hear, Ms. Sauer, is it concurrent, both cases?
That's correct.
Okay, all right.
Okay.
So what are we doing?
The only thing that we were changing would be on position 7, credit for time served, 3 days, 6 days, credit for time served, 3 days. Okay. Mr. Clark, it's my understanding that in case 22 CR 007879Y, you wish to plead guilty to willful obstruction of a law enforcement officer, theft by shoplifting, and criminal trespass. Is that correct?
Judge, can I have a second? He had a quick question for me.
Oh, okay. Go ahead.
And Your Honor, I did confirm it was 3 days, so we will make that amendment.
Thank you.
Thank you, Judge. We're ready.
Okay. Mr. Clark, it's my understanding that in case 22 CR 007879Y, you wish to plead guilty to willful obstruction of a law enforcement officer, theft by shoplifting, and criminal trespass. And in case 22 CR 003264Y, you wish to plead guilty to criminal trespass and damage to property, giving false information to law enforcement, and obstruction of a law enforcement officer. Is that correct?
That's affirmative.
Are you under the influence of any drugs or alcohol this morning?
Negative.
You've been represented by counsel. Are you satisfied with his representation?
Excellent.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Affirmative.
Has anyone forced or coerced you to plead guilty?
Negative.
I'll accept the pleas as negotiated, Mr. Clark. I am going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Actually, you don't have to report anymore after you finish all requirements. Okay, all right. Judge, I did want to inquire, of maybe Mr. Jordan or maybe Ms. Sari can clear this up for me. That on his booking screen, there's a 22 FTA number. Is that associated with this, either one of these cases? And if so, I guess we would need to address that or clear that up because it is showing something that can potentially hold him if it resolves his other matters. So I wanted to clarify that. It's a 000.
Which case are you on, Judge?
It says 22 FTA 000029. Is that FTA related to either one of these misdemeanor cases?
I don't believe so. I'm looking at it. It says it's a felony.
Okay. I just wanted to confirm that to make sure that we didn't need to address that as well.
Okay, anything further with Mr.
Nothing
Ford?
further.
All right, what's your next? Are we ready?
We're all set, Your Honor. Position 15.
Okay, and what are we doing with Mr. Herrera?
This will be a negotiated plea, Your Honor.
Esta es una declaración negociada, Su Señoría.
Let's see, Madam Interpreter, if you'll raise your right hand for me. Do you swear or affirm that you will translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Good morning, Mr. Herrera. I'm Judge Eric Morrow. This is the state all-purpose calendar. We're conducting.
Buenos días, señor Herrera. Yo soy el juez Eric Morrow, que estamos haciendo esto virtualmente.
We're conducting this by video. Do you agree to have your case heard by video?
Estamos conduciendo esto por video. ¿Está usted de acuerdo de hacerlo por video?
Sí.
Yes.
Can you raise your right hand for me?
¿Puede alzar la mano derecha, por favor?
You swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Usted jura que el testimonio que va a dar aquí será la verdad, toda la verdad y nada más que la verdad, lo jura.
Sí.
Yes.
You can put your hand down, sir.
Ya puede bajar la mano.
Ms. Todd?
Thank you, Your Honor. The state's offer is 11 months, 29 days to serve 64 days with credit for time served of 32.
Su señoría, el Estado le está ofreciendo 11 meses, 29 días con 64 días y 32 con 32 cumplidos.
With balance probated.
Y el resto va a ser bajo probatoria, una libertad con condiciones.
Domestic Family Violence Intervention Program.
Y un programa de intervención de violencia contra la familia.
No further contact with the victim.
Y no tener más contacto con la víctima.
A stay away from one sovereign apartments.
Y estar alejado de one sovereign apartments.
And third party transfer for the children.
Y tener las terceras personas para transferir a los niños.
What's the victim's name?
I'm going to unfortunately butcher this. I think it's Osmeida Mayo Quiterio.
¿Y cuál es el nombre de la víctima? Es Osmeida Mayo Quinteiro.
Mr. Ford?
Thank you, Your Honor. We do, my client will be accepting the plea offer at this time, and we're asking that his probation fees be waived, and also that once he completes the condition, that his probation be terminated.
Sí, su señoría, mi cliente va a aceptar la oferta. Estamos pidiendo que ya el que complete con todas las condiciones, que su probatoria sea terminada.
Anything further, Mr.
¿Algo
Ford?
más, señor Ford?
No, nothing further, Your Honor.
No, nada más, su señoría.
I'm not going to terminate the probation, but I will let it go to a non-reporting status.
No voy a terminar la probatoria, pero sí puede que no tiene que estarse reportando.
Okay. Mr. Herrera, it's my understanding that in case 22 CR 007774E, you wish
Señor Herrera, tengo entendido que en el caso 22 CR 0077748,
you wish to plead guilty to battery family violence. Is that correct?
y usted desea declararse al golpes contra la familia. ¿Así es?
Sí.
Yes.
Are you under the influence of any drugs or alcohol this morning?
¿Usted está bajo la influencia de alguna droga o alcohol esta mañana?
No.
No.
You've been represented by counsel. Are you satisfied with his representation?
¿Usted ha estado representado por un abogado? ¿Está satisfecho usted con la representación de él?
Sí.
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
Usted entiende que usted tiene el derecho de tener un juicio ante un jurado, pero al declararse culpable está renunciando a tener ese juicio.
¿Está bien?
That's fine.
Has anyone forced you to plead guilty?
¿Alguien lo ha forzado a usted para que se declare culpable?
No.
No.
I'll accept the plea as negotiated.
Acepto la declaración como lo han negociado.
I am going to waive the probation fees for you while you're on probation.
Voy a diferir las cuotas de la probatoria mientras esté en probatoria.
And when you complete the terms, it'll go to a non-reporting status.
Y cuando usted complete con todas las condiciones, va a estar en estatus de que no tiene que estarse reportando.
¿Está bien?
That's fine.
And good luck to you, sir.
Buena suerte a usted, señor.
Okay, gracias.
Yes, thank you.
All right, thank you, Madam Interpreter. We appreciate
Thank
it.
you. Am I needed for anything else?
Do we need the interpreter for anything else this morning?
Not in my cases, Your Honor. I don't know what the other PDs.
Hey, Derek, can you be interpreter? No.
Ms. Helen?
No, Judge, we don't need the interpreter. Thank you.
All right, thank you, ma'am. We appreciate it.
Thank you. Bye-bye.
Bye. Who do we have next?
Hasta luego, mi amigo. Bye.
Position 20, Magar.
This is going to be a non-negotiated.
That's correct, Judge.
Good morning, Mr. Magyar. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah, sure.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, sir. Ms. Todd?
Yes, Your Honor, the state's offer in this case is 12 months to serve 32 days, credit for time served 16 days, no further contact with the victim, Miss Amada Magyar, a stay away from the Ms. Magyar's home of 225 Worthington Hills Trace, 6 weeks anger management, as well as a mental health evaluation.
Ms. Helen?
Yes, Judge, this is a non-negotiated plea just for 2 things, Judge. When I went and spoke to Magyar, he stated that he has permission to come and go at that location, that he's had previous, that he's lived at that location with his mother. So he was under the impression, Judge, that that was his residence and that he could come and go as he pleased, Judge. In this particular situation, I believe Ms. Magyar is his mom. So a stay away from mom, it would be really hard for Mr. Joseph right now. But I'd also like the sound for Ms. Magyar. Joseph is under the impression that she's going to allow him back to the home. And so, and we just want to see if she's here at the Zoom call to possibly speak to that.
If Ms. Magyar is present, this is your opportunity to address the court if you choose to do so. You'll have to unmute yourself and activate your camera if you would like to address the court. Doesn't appear that she's here, Ms. Helen. Ms. Helen, did you make a representation to the court that you have spoken with her?
Ms. Magyar, no, I've actually spoken to Joseph, and Joseph has had not recent contacts, but the last time he spoke to her, that he was under the impression that he was allowed to be able to come back to that residence, Judge. I have not spoken to Mom. I'm just under the impression from Joseph that she would allow him to come back home because he was residing there.
well, Ms. Todd, has your office, the victim advocate, been able to speak with her?
Let me check with my victim advocate, Your Honor. I will say, I just want to put on the record that this is the second time that his mother has had to call the police to have him criminally trespassed from her home. So we don't believe that this is an isolated incident. Therefore, we do believe that a stay away is appropriate in this case. And I just heard back from my victim advocate. We have not been able to get in contact with Ms. Magyar.
Okay, Ms. Heller, knowing that no one neither you or the state has spoken with Ms. Magyar, I am not going to allow him to go back to that residence or to have any contact at the present time, unless and if it does not appear that she's here for today's hearing, and if it's his mother and she wants him back, she wants him to have contact with her, I would imagine that she would be here this morning. So I'm not going to allow contact and a stay away. If he has belongings at that address, I will give him a one-time escort with the law enforcement to retrieve any belongings that he might have.
And Judge, right now, Mr. Magyar does not have employment. So the only issue with the 6-week anger management was that he's not able to afford it. If the state is amenable, just some type of substitution of community service. And Judge, I just spoken to Magyar. Again, I was trying to find something comparable for him to do. He's not able to afford it, Judge. He's also not able to get there, Judge. So he's not able to do these conditions. And I'm just petitioning the court if we could do some type of balance suspended with the condition of getting the MHET.
I don't believe that MHET would be recommended unless or accepted by Mr. Magyar, unless there might be an issue. I think it might be more of an issue of mental health. He has been in custody for 16 days on these matters. So I would not require him to have the 6 weeks of anger management, but he will have to have the MHET. No further contact and a stay away.
I apologize.
You're fine. Go ahead. Mr.
And yes, Your Honor, I've spoken to him about the MHET. He'd be willing to do that and perform that task, Judge.
Give me one moment, please.
Bye, John.
All right, have a good day. Yes. Okay, I'm sorry. There's counsel in the courtroom with me that I was discussing another matter on. Let me complete, Mr.
Magyar.
Mr. Magyar's matter. It's my understanding, Ms. Helen, that, he is, accepting of these terms.
He's a, yes, Your Honor, of the MHET, and where to be able to get that actually done, we've just discussed, Judge.
All right. Anything further on Mr. Magyar before I take the plea?
No, Your Honor.
Nothing from the state.
Mr. Magyar, it's my understanding that in case 22 CR 008021H, you wish to plead guilty to simple assault, family violence, and criminal trespass. Is that correct?
No, not guilty.
Hold on one second.
First thing, Mr.
I apologize, Your Honor. We just had some clarification there. Can you repeat that question for him?
It's my understanding you wish to plead guilty to simple assault, family violence, and criminal trespass.
I'll accept time, sir.
Okay, Mr. Magyar, if you can answer my question, I understand that it is going to be a time served plea, but it's my understanding that you wish to plead guilty to these charges. Am I right?
Well, no one showed up, so either way, I go home.
No. Judge, can I have one moment, please?
I think we need more time with Mr. Magyar. I'm not sure if he is understanding what is happening today. I feel uncomfortable taking the plea as it stands, so.
I'll go ahead and plead guilty.
Miss Helen. You tell me, Miss Helen.
I'm speaking to Mr. Magyar. He is understanding of what we're doing. He's understanding that he is entering a plea of guilt. I think he just needed clarification on the actual words. Yes, Judge. Again, we're just clarifying there. If you could ask him that question one more time.
Mr. Magyar, do you wish to plead guilty to simple assault, family violence, and criminal trespass today?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Ms. Helen. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anybody forced you to plead guilty?
No.
All right, so the sentence is going to be 12 months to serve 32 days, credit for time served 16 days, a mental health evaluation and treatment if necessary, and a stay away from Mrs. Magyar and the Worthington address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. I'm going to waive the fees for him while he's on probation to help him get and stay on his feet. And when he completes the MHET, it can go to a non-reporting status. Ms. Helen, I need for you to impress upon him that he cannot go back to that address or to have any communication with his mother at the present time. You understand? Would you please impress that upon him and what no communication means, okay? Because if he violates this order, he understands that the probation is going to be revoked.
Yes, Judge, I understand, and we have had that conversation. I will reiterate that same information to him, Judge.
Okay, very good. Thank you. Good luck to you, Mr. Magyar. Courtroom 2, I have an announcement on position number 3, Mr. Corey Barkley. Mr. Barkley's attorney was in court, Mr. Tom Ford. Mr. Ford is going to enter a notice of appearance on behalf of Mr. Barkley. He's also going to file a written waiver of arraignment in the matter, and the matter is going to go to jail jury. Okay, so we will not meet Mr. Barkley this morning.
Good.
Okay. Who do we have next?
Position 25.
Who's representing Mr. Richardson?
Sir, I had a private attorney, Marcus Oliver, but I was not informed that I had court date today, and he's not present either. I was wondering if I could get a public defender to see my case today.
Have you hired? What is the attorney's name, Mr. Richardson?
Marcus Oliver.
Marcus Oliver.
Yes, sir.
Okay. Mr. Richardson, the state is recommending 24 months to serve 365 days in your case. What I'm going to allow you to do is we need to see if we can raise Mr. Oliver in that regard. And if he is not representing you, then I will certainly allow. He is representing. Okay, there is an entry of appearance for Mr. Oliver, so I'll give him the opportunity to address the court. I'm going to have to reset you, Mr. Richardson, until next Tuesday. Okay, so that's going to be 12/20. So I'm going to give him. Yes, 12/20. So I'm going to give him the opportunity to be at your next court appearance. We'll reach out to him and let him know that we're going to see you next week. Okay?
Okay, thank you, sir.
You're welcome. I'll see you back next week, sir.
All right.
Who do we have next?
16, Mr. Jackson.
And
Good morning, Judge.
Good morning again, Mr. Murphy. What are we going to do? With,
Judge.
Yes.
On Christopher Jackson, after seeing you last week, I went to see Mr. Jackson at the Fulton Jail. He has confirmed that there is a probationary hold. So I was asking the court to reset it 1 week out so I can have probation be aware of this, and perhaps I can calendar it and see what kind of sanction that they may be inclined to do before we can decide what we want to do on this underlying new charge.
Okay, so you want me to reset this till next Tuesday?
That's correct, Judge.
Okay, so that's 12/20. All right, so we'll do that. That's fine, Mr. Murphy. So Mr. Jackson, we'll see you back next week.
Thank you, Judge. Mr. Jackson, I'll be in touch with your family. Thank you, Judge. That's all I have.
All right, have a good day. Appreciate it, Mr. Murphy. Who do we have next?
Position 17, Johnson. And he said that he was holding for private attorney, Mr. Butterfield, Torrance Butterfield.
Right, we have Mr. Butterfield as the attorney. So have we heard from Mr. Butterfield?
This young man, he called his mom to have her to let him know that he has court today.
Okay, let's see. Given that the state's recommendation is 180 days to serve with credit for time served 2 days, Mr. Johnson, I'm going to reset your case also till next Tuesday to give Mr. Butterfield a chance to appear on your behalf so that we can move the case forward. So we'll reset your case also to next Tuesday, 12/20. And if we can make sure that we contact Mr. Butterfield to let him know he needs to be in court next Tuesday. All right. Well, I'll see you back next Tuesday, Mr. Johnson.
All right, thank you. Have a good day.
You have a good day also. I'll see you next week, sir. Who do we have next?
Position 21, Matthews.
And this is going to be a negotiated plea.
That's correct, Judge.
Good morning, Mr. Matthews. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Matthews. Ms. Todd?
Yes, Your Honor. The state's offer is 12 months to serve 34 days, credit for time served 17 days, with the balance probated, no further contact with the victim, FVIP, and a stay away.
Can we have the stay away address?
Yes, we can. That address is going to be 2233 Macon Drive Southwest.
And the no further contacts?
The no further contact is going to be with the victim, Marcel Copeland.
Yes, Judge, that is our understanding of the plea. We do accept that plea, Judge. It is a probated sentence and Mr. Matthews has lost all employment due to incarceration. So we are asking for those probation fees to be waived, Judge.
Okay. Mr. Matthews, it's my understanding that in case 22 CR 007982Y, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You being represented by counsel. Are you satisfied with your representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Matthews. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Okay.
Thank you, Judge.
Good luck to you, Mr. Matthews.
Positions 4 and 5, he's on the add-on, Mr. Hill.
And I have that position 4 is going to be Norcross, and position 5, there's going to be a plea. Is that right?
That is my understanding, Your Honor.
That's correct, Your Honor.
Okay. Good morning, Mr. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning, Judge.
Good morning, sir. Can you raise your right hand for me?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hands down. Thank you. Mr. Walker?
Yes, to position 5, the state's recommendation is 12 months to serve, 30 days, credit for time served of 30 days. Balance probated, no further violent contact with the victim, whose name is Valencia Hill. An alcohol and drug evaluation with any necessary treatment, and an 8-week anger management program. In exchange for this plea, we will be null processing position 4.
Okay. Mr. Ford?
Yes, Your Honor, we do concur with the state's recommendation. We do waive, we do stipulate to the factual basis, venue, and ID. And I've gone over the plea form with my client.
Mr. Hill, it's my understanding that in case 20 CR 004948F, you wish to plead guilty to simple assault, family violence, and criminal trespass and damage to property. Is that correct?
Yes, sir, that is.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Hill, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
All right, thank you so much, Judge.
Okay, you're welcome. And Mr. Walker, can we get the victim's name?
Valencia Hill. VALENCIA. Common spelling for Hill.
Okay, thank you. All right, good luck to you, Mr. Hill.
All right, thank you so much.
Who do we have next?
Position 11, Curtis.
And this is going to be a negotiated plea, is that right?
Let's see. Yes, Your Honor.
Okay, Mr. Curtis, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Curtis. Ms. Sowry?
Yes, Your Honor. The state's offer in this case is 12 months to serve, 365 days. Credit for time served, 365. The balance suspended. No contact with Vontori. That's VONTORI. Last name Manuel, common spelling. We initially had the restitution condition on there, but we will remove that after speaking with the victim. Nothing further.
Your Honor, my client has a few things he wants to talk to me about right now. I don't know if you can move to another. I did see him. He was in Cobb County Jail last night. I did go visit with him, but he has some questions that I feel I need to answer before we move forward.
Okay, that's fine, Mr. Ford. Who can we take next?
Position 4, Cavalario.
That's me, Your Honor.
This is going to be a plea also?
That's correct, Your Honor.
Good morning, Mr. Caballero. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Sowry?
Yes, Your Honor. The offer is 12 months to serve 14 days. Credit for time served 14 days. The balance suspended. Balance probated. No contact with the victim. Stay away from 621 North Highland Avenue, Northeast in Atlanta. The victim's name is Kendall Thomas Chaku. In restitution, he is on the call, Your Honor, so if you may sound for him.
I see Mr. Thomas there.
Yes.
Would you like to have him say something, Ms. Sowry?
If he would like to speak to the restitution amount.
Mr. Thomas, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Go ahead, if you'd like to speak to the restitution.
I don't know about restitution, but I was gonna say I wanted to downgrade the order to like non-violent contact, if that's possible. And then it doesn't have to be a stay away. If he gets to or agrees to get some type of treatment, then I'm fine with him coming over. That's my main concern, but I don't know if that applies here.
Well, the recommendation from the state is he's served 14 days in jail, and that's what his sentence is going to be. If you would like restitution in the matter, I'm happy to hear about that. But if you don't want restitution,
No, I'm okay without it. The damage has already been repaired by my complex.
Okay, Your Honor, so we will remove the restitution amount. We'll defer to the court regarding the contact order, and instead of the balance being probated, we'll ask for balance suspended.
okay. So you don't mind having contact with him, Mr. Thomas? Is that what you're telling me?
No,
Are you afraid of him?
no.
Okay. All right, so the order will be no further violent contact with you, Mr. Thomas. All right. All right, thank you, Mr. Thomas. We appreciate it.
Thank you.
Let's see, Mr. Ford.
Thank you, Your Honor. Your Honor, I reviewed this case with my client yesterday, and he does concur with the balance suspended, time served, also the no further violent contact. You understand what that means? Yes. Okay, no further violent contact, Your Honor. So would that also remove the stay away, Your Honor?
Yes.
Okay, yeah, so my client does concur with the recommendation. We ask that his probation fees be waived, and that when there's no probation. So, Your Honor, so we concur with the recommendation, and we do stipulate to the factual basis, venue, and ID.
All right, Mr. Cabrera, it's my understanding that in case 22 CR 008049J, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
That's correct.
Were you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated. 12 months to serve 14 days, credit for time served 14 days, balance suspended, no further violent contact with Mr. Thomas. Good luck to you, sir.
Thank you. Thank you, Your Honor.
Position 13, Dewberry.
This is going to be a non-negotiated.
Yes, Your Honor.
Good morning, Mr. Dewberry. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Dewberry. May I get his history, please, Ms. Harrison?
One moment, Judge. He has 54 cycles. Last arrest was, one moment, February of this year, failure to appear in DeKalb County. Underlying charge is not indicated. Record does indicate an open case pending in Fulton County for criminal damage to property, second degree, 22 CP 214276. Three violations of probation within the past 10 years. He has a 2010 robbery conviction out of Spalding County. A 2020 criminal trespass, also out of DeKalb. And a 2021 theft by shoplifting. Nothing further, Judge. That's within the past 10 years.
Is the pending criminal damage to property in state court?
It's felony.
Oh, okay, thank you. Ms. Sari?
Yes, Your Honor. In this case, officers responded to Videodrome located at 617 North Highland Avenue, Northeast in Atlanta. They were responding regarding a trespass call. The defendant had came onto the property with a metal stick and struck the door with the stick. And once the handle broke off, he threw the handle into the street. Your Honor, this defendant has been trespassed at least 3 times from this incident location, and he's been giving multiple stay away orders, but he is still violating. The reason that we are asking for more jail time in this case is because, Your Honor, in October of this year, this defendant pled guilty to criminal trespass at the same incident location. That plea was taken by Judge Law, and he was given time served. That was a month before this incident, and he has violated that stay away order. Earlier last month, he pled guilty to criminal trespass at a different incident location. Your Honor, you actually took that plea. We gave him time served again, and that was 5 days before this incident. And then, as we've heard from pretrial, the open criminal damage to property in Superior Court, Your Honor. So we are asking for more jail time because the defendant presents a risk of reoffending. Regardless of us giving him time served in each case, he comes back before our court. So we are recommending 12 months to serve 60 days, credit for time served 18 days, the balance probated, a 6-week anger management, to stay away from Videodrome at 617 North Highland Avenue in Atlanta. Nothing further.
Mr. Ford?
Thank you, Your Honor. Your Honor, at the present time, my client is residentially challenged. I see that he's had some criminal trespass cases, but I think that's due to his current situation. I have spoken with him about Gateway. He knows where Gateway is. He understands that he'll be able to get services. He'll be able to have a place to stay and to start earning money for himself. Your Honor, I don't believe that this case warrants any more jail time. At this point, he has served 18 days. The state is asking for 60 days, which will be a total of 12 days of actual jail time. Your Honor, I don't think 12 days more for Mr. Dewberry would prove to be of any benefit at this point, other than the fact that he has an open case that he is trying to make bond on. He does not have the means at this time. Hopefully that he will get a reduced or a signature bond on the open case. It is a criminal trespass case as well, Your Honor. We're asking that, I think, to help Mr. Dewberry at this time so he doesn't continue to do anything that will harm his criminal history. I would ask that we give him time served, balance suspended, and we also waive the anger management. At this point, Your Honor, I don't believe my client has an anger problem. There's been a couple of misunderstandings, but at this point, Your Honor, we're asking that there'll be time served and balance suspended and no anger management at this time.
And Your Honor, the criminal trespasses, they do involve damage to these different businesses. So it's not simply him, just going onto the property. He's committing violence towards the businesses. So we just wanted to make that clear for the court.
Has he, I'm sorry, you've said that he's, I know he's been trespassed from Videodrome. Were any of those other cases that you mentioned us to stay away from Videodrome?
Yes, Your Honor. In October of this year, he was told to stay away from Videodrome. That was by Judge Law, and the case number is 22CR 007396F.
Okay. What's the issue with going back to Videodrome, Mr. Ford?
Is it? Yeah, you know. Oh, yeah. Your Honor, that's where the misunderstanding is coming into. He has a friend that works at Videodrome, and he did not realize that he was totally barred from going there, Your Honor. So that's why he's willing to plead to the criminal trespass. But we do not believe that the extra 12 days that the state is asking for is of any benefit at this time. He would like to deal with this open case. I think he's going to get a bond on that one, so he can then move on to Gateway and he's willing to do what's necessary to remain there so he can move on and have a more productive life at this time, Your Honor. So we believe that the balance suspended on this case would be appropriate. He does not have the money to pay for the anger management courses. All that would do, Your Honor, would be to place him back in a disadvantaged situation, maybe move him back here because he does not have the money to pay for the anger management, and he would probably be violated, and we'll be dealing with Mr. Dewberry's case again. So he's willing to plead today, Your Honor, but we're asking for time served plus no anger management courses at this time, so balance will be suspended.
Okay, well, I'm not gonna give him time served because I've given him time served before. Judge Lowell has given him time served before. I always make it clear that, and everyone comes back and they say, I didn't understand that I couldn't go back to the Videodrome. Well, you can't go back to the Videodrome, period. You cannot be on that property. You certainly cannot be committing any damage to the property. So I can't keep giving Mr. Dewberry time served, and he comes right back and does the same thing. I am willing to work with him in regards to the anger management because I don't want him to set him up for failure. I do want him to go to Gateway once he gets out, but the sentence will be 12 months to serve, 60 days, credit for time served, 18 days, ballot suspended, and stay away from the Videodrome if he is willing to accept that.
You want to accept it? Yeah, he says, no anger management, but you gotta stay away from the beat. My client is in agreement with that, Your Honor.
Okay. Mr. Dewberry, it's my understanding, anything further from counsel?
Nothing further, Your Honor.
Nothing further from the state.
Other than Wally, well, no, nothing further, Your Honor.
Okay. Mr. Dewberry, it's my understanding that in case 22 CR 007979E, that you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and if by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Dewberry. The sentence is going to be 12 months to serve, 60 days, credit for time served, 18 days, balance suspended, and a stay away from the Videodrome. Stay away means you cannot go back there, okay? If you go back there and get arrested again, then the sentence is going to go up from here.
No,
Okay, so, all right, so do not go back there. And Mr. Ford, if you can help him, as you said that you would, with placement at Gateway, that would certainly be helpful to the court to get him right there.
Dewberry, once he contacts us after he's released, we will definitely make sure that he gets a chance to go to Gateway.
Okay, good luck to you, Mr. Dewberry.
Okay.
Thank you.
Judge Morrow, I do have a quick announcement for position 19.
Okay.
It's going to be a loan out to Grady.
Okay.
He's also position 7 on the add-on.
Oh, and he's also position 7 on the add-on. Thank you.
And should I reschedule that for next week?
Yes, Your Honor.
Okay. 7 add-on is reset to 1220 and 19 reset 1220. Okay, thank you. Who do we have next?
The last case we have, Judge, going back to position 11, Mr. Curtis. But I believe he still needs to talk to you for, right?
Do it.
Okay, I'm sorry, tell me that number again.
Position 11, Mr. Curtis.
Okay.
Okay, hold on. You may have to have a little copy. I apologize, Your Honor, I did not get a chance to.
Oh, you're fine, Mr. Ford. Who's representing Mr. Watson today on the, I've got a non-jail final plea calendar. Is that going forward today?
Yes, I negotiated that with Attorney McLean, and it was a time serve offer.
Has the paperwork been done, Mr. Walker?
And Mr. McLean will have to answer that.
Judge, Mr. McLean's not here today. I haven't received that paperwork, but I do have, some paperwork here that I can fill out for Mr. Watson. I would just need, to just verify the terms. And if Mr. Watson's on the Zoom link, if he could give me a call here at the courtroom, that would be great.
Is that under Brian's iPhone? Is that Brian Watson?
I'm right here.
Okay, so how do you want to do this? Do you want to?
I'm gonna text him the number, and if he could just call me here at the jail, that'd be great.
Okay, all right. So Mr. Watson, if you'll do that for us, okay?
Okay.
And then PD Helen is just time serve of 2 days.
Thank you so much. There, stay away.
Nope, just time serve 2 days.
Thank you so much.
And we'll also have a bench warrant set for DVK set for 11. Also, is Travis Walker on the line?
It's over.
Yes, sir.
Okay. Good morning, Mr. Walker. Can you actually?
Good morning.
Oh, Your Honor, we're set with Mr. Curtis before we go to Mr. Walker.
Okay, I'm not going to Mr. Walker. I'm just trying to see who's with us so that I can move the cases forward. Who's representing Mr. Walker today?
I am, Your Honor.
Okay, all right. So Mr. Walker, good morning. If you'll stand by for us, we'll be with you, okay?
Good morning, sir. No problem.
Thank you. All right, so Mr. Curtis, what are we doing with Mr. Curtis?
This will be, I believe, a negotiated plea, Your Honor. Hold on, let me make sure I got it right in my note. Yes, a negotiated plea.
Okay. Ms. Sari? Oh, I don't remember if I went through with Mr. Curtis, so I'm going to start from the top with him. Mr. Curtis, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can put your hand down. Ms. Sari?
Yes, Your Honor, the state's offer in this case, I've stated it is 12 months to serve, 365, credit for time served, 365. So there's no balance and no contact with Vontori manual, and we will remove the restitution condition, nothing further.
Mr. Ford?
Yes, Your Honor, we do concur with the state's offer. I have gone over the plea form with with Mr. Curtis last night and at the Cobb jail. And we do stipulate to the factual basis being an ID.
Okay. Mr. Curtis, it's my understanding that in case 22 CR 008015E, you wish to plead guilty to hit and run, is that correct? And failure to obey a stop sign?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with his representation?
100%.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Curtis. Good luck to you, sir.
Judge, we're completed here in courtroom 2.
Okay, thank you. Let's see, we still, I guess, are going to need to be there for these last 2 cases. But I'll see you next time. Thank you.
Cool. The number is 392. Yeah.
Okay, Mr. Ford, you're going to need to speak with
No, I had an opportunity to speak to Mr. Walker yesterday, Your Honor.
Okay, so let's go ahead with Mr. Walker's case, position 1 on the DV bench warrant case. Ms. Sari?
Yes, Your Honor, if we may hear the history from pretrial.
One moment.
Can you tell me what he missed, Ms. Sari?
Yes, Your Honor, I'm sorry, I'm pulling it up now. It was a plea and arraignment calendar from 11/10.
Whose court?
Judge Mather.
He has one arrest in Georgia for battery. That was a, 1 second, Judge. One arrest in Georgia, that was June of 2020, family violence battery misdemeanor. It appears to be a no-low. And he has 6 cycles out of New York. Nothing further, Judge.
Anything further, Ms. Sally?
Your Honor, the state is asking for the bench warrant to remain. As we've heard from pretrial, the defendant does have history from out of state, so he does present a risk of reoffending. I also had, in our jurisdiction, there was a battery amended to disorderly conduct, so he does have a history of violence. Briefly, Your Honor, this incident took place at 1346 Westman Road in Atlanta. Officers responded and spoke with the victim, whose name is Tashonda Dixon. She stated that she and the defendant got into an argument over their infant daughter's milk when a verbal altercation ensued, and then the defendant struck her multiple times. So the state is recommending that the bench warrant remain due to his history, and nothing further, Your Honor.
Mr. Ford? You're on mute.
I didn't know I was in control here, Your Honor, so apologize for being mute.
You're fine. And I'm ready for you when you're ready.
All right, Your Honor, I was just waiting for it to calm down just a little bit here.
Oh, okay.
Your Honor, my client is, I believe 43 years old. He is a high school graduate from New York, but also he has a bachelor's degree in culinary arts. He is right now an executive banquet chef at the Marriott Hotel here in Midtown. He has been working there since 2017. He's not a risk of flight, Your Honor, due to the fact that he's been permanently employed here for over the last 5 years. He has 4 children, 3 dependents at this time, ranging from the ages of 1 to 16 years of age. Excuse me, Your Honor, I'm just trying to wait for it to calm down a little more. All right, Your Honor, he has a stable address here in Georgia, also telephone number and email address. He has given me a telephone number of one of his children's mother, so he does have community support here in the state of Georgia. Your Honor, he missed his plea and arraignment scheduled date because he just said that he did not receive the notice. So we're asking that, and Mr. Walker is not someone who's going to dodge going to court due to the fact that he is gainfully employed and has people to support at this time financially. So we're asking that the bench warrant be set aside, Your Honor, and Mr. Walker is given an opportunity to attend court and take care of this charge.
Was his notice returned?
That's what I was going to state, Your Honor. I don't see anything regarding any return notice.
Can you tell me what address it was sent to?
I'm looking, I'm sorry. It was the 1346 Westman Road.
1346?
46, that's correct.
Yeah, because he gave me an address of 1314 Westmont Road.
What's the correct address, Mr. Walker?
No, it is 1346.
Is it? Because I've got 1314.
Yeah. I guess
Westmont.
you probably didn't hear me clearly.
Okay, thank you.
Okay, well, you should have gotten notice, Mr. Walker.
Your Honor, I never received it unless I would appear at court, whatever. I have no reason to, to dodge court.
All right, so this court normally gives you one opportunity. I don't know what happened with your notice. It appears that it was sent to the right address, but it's going to be your responsibility from here on out to make sure that you stay in touch with the court regarding court dates. And that's Mr. Walker. I don't see you there, but I
just like to provide. I just want to get some clarification. Is he saying that's his current address?
Mr. Walker?
Yes.
Yes. Okay, because that's the stay away.
Yes, it is.
Order, so that's obviously an issue.
There's a stay away?
From what I just pulled from Odyssey, I can double check because I was reading rather quickly. But let me pull it up again.
And that is the incident location, Your Honor, so.
Does anybody have the bond order?
Yeah.
I do, yeah, but.
It was Judge Law, August 23rd, I believe. So obviously the defendant is in violation of his bond order, so we definitely are not going to agree to the sit aside and ask that he's remanded into custody.
Read it to me, Mr. Walker.
No further contact with Tashonda Dixon. I believe those three individuals listed by their initials are the three children. Stay away from 1346 Westmont Road, a one-time escort to retrieve items. Judge Law on August 23rd of this year. And then he turned around, submit paperwork to the clerk's office with the same address on it as his current address.
All right, so Mr. Walker, you have a right to remain silent. Anything you say can be used against you. Mr. Ford, you need to talk to Mr. Walker. I'm going to reset this till next Tuesday, which will give Mr. Walker 7 days to find himself a new address if he's in fact living at 1346 Westmont Road. And I will address this bench warrant at that time. Mr. Walker, it is clear that you're not supposed to have any contact with the alleged victim. It is clear that you're not supposed to be at the
Your Honor.
Westmont Road address.
Your Honor.
Again, Mr. Walker, I'll listen to you, but I just want to make sure you know you have a right to remain silent. Anything you say can be used against you. You have solicitors here that are listening to everything that you have to say. So
no problem.
Okay. Yes, sir.
No problem. Tashonda Dixon does not reside at 1346 Westmont Road.
Okay, so Mr. Walker, you still on the line?
I'm here. It doesn't say that if she doesn't reside, he can return. Judge Law is pretty specific about her orders. And if she does not reside, the bond still would need to be modified, which has not occurred.
Exactly. So that's what we will do. If you will, by next week, have your victim advocate get in touch with the alleged victim in the case to clarify where she's living and some of the issues, and report back to me next week.
Yes, Your Honor.
Okay, and he's correct, Mr. Travis Walker, that just because she's not living there does not mean that you can be there without this bond order being modified. So if that's the case, then I'll take that up next week also.
Sir, I understand that whatever. I have been staying at 861 DeSoto Avenue.
Walker, I would ask that we wait till the recess date before you say anything else, okay?
No problem.
Okay, so you get in touch with him, Mr. Ford. You all work all this out, and I'll hear back from everybody next Tuesday.
All right. Thank you, Your Honor.
Thank you. And it'll remain where it is at the present time. Okay, so we have one more case. Is that right? Is Mr. Brian Watson ready? You're free to go, Mr. Walker.
Thank you. Have a great day, sir.
Mr. Walker, I will be in contact with you, okay?
No problem, Mr. Ford. Thank you. Have a great day.
Yes, Judge, we're ready. That's gonna be a negotiated plea.
Okay, Mr. Watson, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor, the state's recommendation is time served of 2 days.
Ms. Heller?
And yes, Judge, that is our understanding of the plea. We ask this court to accept that plea as negotiated.
All right, Mr. Watson, it's my understanding that in case 16 CR 006101A, you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Watson. Good luck to you, sir.
Thank you. Have a great day.
You also.
Thank you.
Okay, I have, again, Ms. Grace in court with me today, and as soon as she is ready, we'll go over the calendar. Okay.
Position number 1, we set jail jury with an amended bond order for 10,000. Position number 2, reset 1220 SAP. Position number 3, reset jail jury. Position number 4 was a plea. Position number 5, reset jail jury remaining. Position number 6 was a plea. Position 7 and 8 were plea. Position 9 was a plea. Position 10, reset jail jury. Position 11 was a plea. Position 12, reset jail jury. Position 13 was a plea. Position 14, arraigned reset jail jury. Position 15 was a plea. Position 16 and 17, reset 1220 SAP. Position 18 was a plea. Position 19, reset 1220 SAP. Position 20 was a plea. Position 21 was a plea. Position 22, reset jail jury with an amended bond order of 10,000. Position 23, reset jail jury. Position 24 was a plea. Position 25, reset 1220 SAP. Position 26 was a plea. Position 27, reset 1220 to Judge Taylor. Position 28, reset jail jury. Position 29 was a plea. The add-on calendar, position 1 was a plea. Position 2 was the range reset jail jury. Position 3, non-pros. Position 4, non-pros. Position 5 was a plea. Position 6, reset 1220 SVP. Position 7, reset 1220 SVP. And final count that was time served and everything. And these corridors over reset 1220 SVP. Questions or concerns?
If not, if you all would please put your paperwork in as soon as possible so that we can get that signed and entered. Well, I don't know if anybody's still on here, but if you are, have a good day. I'll talk to you later.
All right, thank you, Judge. Bye.
Okay, thank you.
Thank you, Judge.